What's at stake for the president here?
Yes. A lot of things, and there are many things at stake for the country. Think about the institutional proposition the president's personal attorneys have laid before the Supreme Court, that no president, not Donald Trump, no successor to Donald Trump, should ever even be investigated, and only investigations can begin after their term of office. Well, think about the implications of that legal argument, that the president, while president, appoints and can see confirmed federal judges all the way up to the Supreme Court, can people the Justice Department with all manner of U.S. attorneys and investigators and the like, and those powers create an atmosphere around his perception and the application of justice. And all that time, he is immune, not just this president, but every future president, from any inquiry into whether he did anything in violation of law, even if that inquiry is about conduct before he became president. It establishes essentially blanket immunity for anyone seeking the presidency and any activity before becoming president and while occupying that office. Keir described it as an aggressive assertion. I would call it without precedent in our history, legally. And that's something that I think creates a larger political context around the president's orientation to something he's been talking about with some frequency lately, law and order. And to your point, Marie, the three entities implicated in this are Mazars, which is his accounting firm, the president's accounting firm, Capital One, a bank, Deutsche Bank, another bank. And one of the interesting dimensions of this is, in two previous cases, Richard Nixon and Bill Clinton, both presidents asserted and lost before the Supreme Court that they should not be personally troubled while president with these either grand jury subpoenas in Richard Nixon's case or a special counsel investigation or an independent counsel investigation or a sexual harassment case brought against President Clinton. And both times the court ruled, no, that does not shield you. In this instance, the president is not personally involved, not personally distracted. His accounting firm and his two banks are, and yet he is tenaciously trying to keep all underlying accounting records, tax records, bank records, insurance filings, and the like away from both Congress and the Manhattan District Attorney's Office in New York. And that doesn't necessarily prove he has something to hide, but his level of aggression about trying to keep all of this as far away from either Congress or a district attorney's office in New York gives you some sense that he might feel more vulnerable if those records were turned over than not.
Yeah, well, certainly, the president, there have been calls for the president's tax returns since he ran for office. Every candidate typically releases their tax returns. The president has used a variety of reasons to explain why he hasn't kept the promise, because he said he was going to, whether he's being audited or his taxes are very, very complicated. And so there are many people that are wondering, should the decision come down against the president in this case, will we actually see the tax returns, his tax returns? Are there any guarantees there?
No guarantees. Remember, the congressional subpoenas don't specifically identify the president's taxes. They seek a wide range of financial records. The Manhattan District Attorney's Office subpoena does seek 8 years, if I remember correctly, of the president's tax returns. But an important distinction here, grand juries operate in secret. It's a crime to release any grand jury material. So even if the grand jury and the district attorney in Manhattan is approved by the Supreme Court to continue its line of inquiry and obtains the tax records, there is no sense and certainly no guarantee that those tax returns would surface before the November election in any public forum. If Congress gets them, and again, its subpoena is not specific to that, but they may be part of the financial records ultimately obtained, then Congress could make a decision to surface them. And one other thing I would point out, Anne-Marie, it's been since Richard Nixon that candidates for the highest office in our country have voluntarily provided tax documentation. It is not required by law, and as the president's defenders and supporters often say, look, he told the country he wasn't going to give them, and under certain circumstances they elected him anyway. The country didn't care. That is a political argument quite outside of the tradition we've established in the post-Nixon era, but it's one the president's supporters frequently point to.
All right, Major, thank you so much. I'm going to put you on hold because Ilya Shapiro is back. He has a decision on precisely what we're talking about. So, Ilya, which case did we get a decision on? Is it both of them? And what are the decisions?
Right now, it's just one of them. It's the Vance case, which involves the Manhattan DA and the grand jury subpoena. The court, by a 7-2 vote, has rejected the Trump argument that there's absolute immunity or some sort of heightened need requirement in this situation. But the court recognizes that there are special circumstances when a state court is demanding something of a president, and therefore they're remanding the case back to the lower courts to determine whatever other challenges the president may have, imposition on his constitutional duties, executive privilege, whatever other issues that he might want to raise. But 7-2, the subpoena is not necessarily invalid, and again, the case will continue in the lower courts to look at what exactly the need is and whether the president has any defenses that might be unique to the presidency or to his or to himself. Again, neither a clean win or a clean loss.
Mm-hmm. And at the core of this particular case was whether or not, I think as Major pointed out, or maybe it was Keir, but that whether or not the president could actually be investigated. Not whether he could be criminally charged, just whether an investigation could be conducted. And the nature of a grand jury is, you know, this sort of stuff is kept secret. It's not supposed to be made available to the public. So can you sort of just flesh it out a little bit?
Yeah, what you said is correct. This is a grand jury subpoena. District Attorney Vance is looking for potential campaign finance and other financial violations under New York state law. So the issue was, to what extent can state courts impose on the president, who after all is the head of the federal executive branch, kind of a supremacy clause issue, federalism issue, things like that. And what the court ruled today, again, 7-2, was that in some circumstances, such subpoenas are valid, and it's we're going to have further legal process about whether the president has other various defenses. But there's not absolute immunity. There's not some heightened standard that these subpoenas need to meet that other kinds don't. So it's, the president still might be a unique actor with unique responsibilities, but that doesn't mean that he's completely immune from process from state courts.
All right, Ilya, that's great. We're going to let you go because we have another decision that we are awaiting, and we want you in position. I want to bring in Keir Dougall again to talk a little bit more about this. So, and you can clarify if I'm not understanding Ilya exactly, but if this goes back down to the lower courts, none of the lower courts agreed with the president's arguments thus far. So, look into your crystal ball. How do you think this bodes for the president?
So, there is a strong presumption of regularity in grand jury subpoenas, and the grand jury has a very broad mandate to investigate. It needs to decide, what happened and who should be charged. These are important issues for the people involved, and so the grand jury generally has a very broad mandate. The president can now, under this opinion, make challenges relating to privilege or try to make arguments about the scope of the grand jury subpoena. But those arguments are typically, in a typical case, they don't go very far. So I would predict that the very large breadth of the material called for by the district attorney subpoena is going to end up being produced here. I am interested, and particularly what I would like to note is the significance of the fact that this court is split 7-2. The Nixon court wasn't split. It was unanimous. At that time, then Associate Justice Rehnquist recused himself. But the remaining justices who did participate in the case were unanimous. The Clinton case was unanimous. I think legal scholars will be very interested to see what the reason for the dissent was. And I would imagine that Chief Justice Roberts worked very hard to try to get as many votes as possible for the decision that's been handed down today, because as an institution, Major was talking about earlier, as an institution, the Supreme Court really does, I believe, need to be concerned about its the appearance of partisanship, the appearance of neutrality. And so, to historically have had cases where effectively the courts were requiring the president to provide information to a court process, both in Nixon and in Clinton, to have those two prior precedents be unanimous and to have this one now be fractured. If I were the Chief Justice, I would be concerned about what that augurs for the court's, political authority, for the public's view of the court going forward. I think that's an important aspect, and as we all have time to digest the dissenting opinions, we'll see what that means for the court for the future.
Yeah, I think that's really interesting. And the other sort of thing that came to mind is the Justice Department under AG Barr asserting that he didn't believe that a sitting president should be prosecuted. And I wonder if there's any implications for the Justice Department, or if that's a whole separate thing, if that's more sort of politics than it is law.
Well, claims like that are particularly concerning, given that prior administrations, when the Justice Department reviewed this question, specifically carved out the question of investigations, because evidence is lost over time, witnesses' memories fade, and so to say that a president is immune from investigation, that an investigation even can't go forward while in office, while the clock continues to run, while documents are potentially lost, while witnesses, potentially may die or may become sick and unavailable, to not even have the ability to gather the evidence that might implicate a president during the president's office is a very aggressive claim, and it's particularly concerning given that it represents a change of position from what the Justice Department has done previously, and it does raise concerns about the rule of law.
It certainly does. Do I have the ability to bring in Major now? I'm not sure about the technology and how it's all working. Okay, great.
Right here,
Major, that's fantastic. We've got a CBS News poll from last month that found that the public is truly divided along partisan lines when it comes to the president releasing his tax returns. You point out that it's been voluntary for candidates to do so, but there have been some sort of ethical requirements once you become the president to release your financial information, and this president has been able to sort of duck and dodge and weave, and I think his latest reasoning now has been because of COVID-19. But there's quite a split. Why do you think this has become such a partisan issue? You would think it would be kind of nonpartisan. It's just about numbers, black and white on a page. We just want to know, where you spend your money and whether or not you may be vulnerable.
Mm-hmm. Sure. Because Donald Trump has changed many of the conversations and many of the assumptions about what is permissible and what is valued in American political life. It was assumed by every candidate in the post-Nixon era that this was a means by which to prove your transparency and your underlying financial ethics. I'm going to release my tax returns. I have my assets or whatever financial wherewithal I possess in a blind trust in order to give you, the voters, greater confidence in my orientation to ethics, business, and the law, and propriety in general. And Donald Trump said, you know what? I don't need to do that. I'm a big business guy. You've seen me on television. I'm a huge real estate tycoon, mogul, whatever adjective you want to apply. That's public enough. I've been visible enough. I have been essentially a success and a failure in the public sphere. I've had bankruptcy filings. I've had casinos rise and fall. My business has succeeded in certain places, not in others. And that's really all the public needs to consume and has consumed. And I'll put my name on the ballot and I'll put my name before them and they can figure it out. And for the Trump campaign, I remember this well, they said, look, in primary after primary and ultimately the general election, the public rendered a judgment. It's not necessary anymore. You don't have to do it. You don't have to bow this era of transparency about your taxes. Donald Trump has changed those rules. One other thing the Trump campaign frequently said is he released a financial disclosure statement. That is true. It's not as comprehensive. It is not nearly as specific as tax returns, but it gave a general idea, and the candidate Trump and then President Trump said a quite favorable one of his overall business holdings and acumen. One of the things that Congress has said about these matters is, did, in every instance, Donald Trump and his organizations accurately represent things to different bodies, to insurance companies, to tax entities? And if the numbers were different, why were they different, and what implications are they to federal law. That's a legitimate, from the Congress's point of view, oversight question. One of the things we're going to find out here in a moment is if the Supreme Court agrees, if that is a legitimate legislative purpose for Congress in requesting these underlying documents. But the president changed the conversation about this. Essentially, you don't need to do what you've done before, and I've rewritten those rules. That's a political context. Now, this has entered a legal world because the president has required it to enter a legal world. And one last point to Keir's very good description of the underlying questions in the Manhattan District Attorney's Office. Remember, we're talking about a crime that's already been prosecuted. Hush money payments engineered with the knowledge of Donald Trump as a candidate to get rid of a political problem weeks before a presidential election. Now, that's a crime there. That's been adjudicated. So it's not as if this is an inquiry into nothing, or an inquiry into something that possibly happened. It's an inquiry alongside something that did happen and was prosecuted. And in our current political atmosphere, that's also highly unusual. And we should remember that as well.
Indeed, and of course that's linked to Michael Cohen's testimony, and that's what the other Supreme Court case is also linked to. Ilya Shapiro is standing by. We have the decision on the final case focused on a congressional committee's subpoenas of financial information from the Trump Organization and Donald Trump himself. Ilya, give us sort of the brief synopsis and the conclusion.
Right. So this is another 7-2 decision, just like the grand jury subpoena case. But this one goes in the president's favor. That is, rejecting the subpoenas as currently framed and having the lower courts, or sending it back to the lower courts to consider the special separation of powers concerns involved when Congress is investigating or seeking information from a president. Same lineup. So John Roberts writes the majority opinion, and the two dissenting justices are Thomas and Alito. And so note, in both of these cases, the president's appointees, Gorsuch and Kavanaugh, voted together and voted with most of the court, which means mostly against the president in the grand jury cases and mostly with the president in the congressional subpoena cases.
That's really interesting. So let's remind people of what the arguments were, because essentially, and you can correct me, the president's attorneys were arguing that this level of intrusion amounts to sort of a type of presidential harassment. The Congress were arguing that they had legislative purpose here, that they were pursuing these documents for a reason. The House Oversight Committee were pursuing documents that were connected to Michael Cohen's testimony, where he said, Donald Trump inflated and deflated his financial worth to avoid paying taxes. The House Financial Services Committee looking into possible money laundering having to do with U.S. properties involving Donald Trump. The House Intelligence Committee investigating whether or not he would be vulnerable to foreign influence. All of them sound like pretty sort of legitimate areas of investigation. So I'm curious, and I know you just got the decision, but can you give us a little more insight into the argument that the majority took?
Right. So they're a little different. In many ways, the congressional subpoena cases are more important because the subpoenas themselves are broader. They're not just investigating his tax returns for evidence of tax fraud or campaign finance violations under New York law. This is looking into the Michael Cohen testimony, as you said, his finances in various ways, the business organizations that he's involved in. I mean, it's a huge scope of what they're looking for. And here the court is saying, look, this is not just a run-of-the-mill person that you're investigating. This is the president, and so there are serious separation of powers concerns. So the court lays out a set of factors that the lower courts should be looking at to narrow the scope of possible conflict between the branches. And they should look at separation of powers concerns, how specific the subpoena's request is, what exact legislative or oversight purpose there is with any given aspect of the subpoena. So really reining in congressional power to investigate the president, making sure they're not on a fishing expedition, and obviously very politically sensitive here. Whereas the other case, the grand jury, which is probably more of a loss for the president because rejecting his argument that he's completely immune, that grand jury subpoena is, well, first of all, it's supposed to be held secret, whatever comes out of it, but also it's more narrow in terms of his financial records for the last few years, not all of this whole investigation into all of his business dealings and Russia and Michael Cohen and all kit and caboodle.
Man, that is really fascinating stuff. Ilya, thank you. I want to bring in Keir Dougall to talk a little bit more about this. So, Keir, your take on this decision, essentially that when it comes to oversight, Congress, I guess, in layman's terms, needs to be way more specific, that it almost sounds like the court is kind of saying, listen, you can't go on a fishing expedition. That's probably what the president's lawyers would argue when it comes to a sitting president. You've got to be specific.
Right. So, first of all, the House case, I think, represented a lot more political exposure for the president than the grand jury case. We've heard already that, of course, the grand jury proceedings are secret. The information that is now going to be produced or may ultimately be produced to the grand jury is not likely to see the light of day unless the grand jury charges someone or evidence is introduced in a court case. So, but the House subpoenas represented political exposure for the president because it would be much more likely that whatever is produced is going to become public quickly. This decision, by remanding or sending the proceedings back to the lower courts, I think is pretty much going to guarantee that the production, the actual handing over of documents won't occur until after the November 3rd election. So the first reaction here is just practical. I think this is a practical win for President Trump in advance of the upcoming November election. On the legal side, the decision itself is it's almost a punt. I mean, look, on the one hand, if you're the recipient of a subpoena, you say, oh, it was a fishing expedition. Look how broad it is. It's unmanageable and it's not tied to the legislative purpose or whatever the purpose of the subpoena supposedly is. On the other hand, if you're the investigator, as I was when I was a federal prosecutor, you often don't know what you don't know. Well, you always don't know what you don't know. You often don't know what you're looking for. So you ask for broad categories of documents so that you don't miss anything. The practice of document production can become one of gamesmanship, where unless if you're the recipient of a subpoena, you can try to interpret the subpoena as narrowly as possible to exclude the documents that would be harmful to your client's cause, and so the difficulty in just sort of waving your hands and saying, oh, this is a fishing expedition, and requiring a specific showing is that you don't know what you're asking for. The court is taking note of the special separation of powers concerns, that they're concerned here about the Congress encroaching upon the domain of the executive branch, and they're asking for a higher showing of exactly why a particular category of documents is relevant. The Congress and the House committees that issued these subpoenas may very well be able to make that extra showing, lay out more of the detail of why they want each of these individual and particular categories of records to support these particular claims, and satisfy the requirement or what the court is asked, the Supreme Court is asking for here. On the other hand, President Trump's in the lower council in the lower courts may be able to say, look, this is too broad, and be able to whittle down particular categories of records.
Keir, I want to ask you about the long-term implications of this, but I know that Paula Reid is standing by, so I just want to get to her because she's busy. So, Paula, it looks like one win and one loss for the president. He actually hasn't had a lot of recent wins with the Supreme Court. There was a LGBTQ rights case that came down against the administration, or not in favor of the administration's argument about another one about protection for dreamers that the Trump Trump administration did not win, and he was really outspoken after those two losses. I'm going to remind people of one of the president's tweets. These horrible and politically charged decisions coming out of the Supreme Court are shotgun blasts into the face of people that are proud to call themselves Republicans or conservatives. We need more justices, or we lose our Second Amendment and everything else. So he also went on to say, vote Trump 2020. It perhaps may be a little bit early because the decisions have just come down, but have we heard anything at all from the administration?
Not yet. We have not gotten reactions to these separate rulings from the White House or the president yet. We have heard from the Manhattan DA just now. He has released a statement on this victory, saying it's a tremendous victory for our nation's system of justice and its founding principles, that no one, not even a president, is above the law. But earlier today, Anne-Marie, the president was on Twitter, and he did not appear to be in a very good mood. He was tweeting generally about presidential harassment, about prosecutorial misconduct. And that's significant because those phrases really mirror the arguments that his lawyers made, especially in the case that he lost. In that case, his lawyers argued that the reason you can't have a state grand jury, state prosecutors seeking financial records from the president is because it potentially opens the president up to political harassment. And the president is not going to be pleased that case opens the possibility of his financial records being released. As you heard from some of our colleagues, the administration, the president's lawyers, they are likely going to try to delay this, try to draw this out and push this past the election. The Supreme Court has given them some wiggle room to kind of go back to the courts and argue that they don't have to necessarily release these. Because remember, it's really significant. It's not the president who would hand these over. It's his bankers, his accounting firms, and those firms have said they will do whatever the Supreme Court tells them to, but the Supreme Court did not directly today order them to hand these over to the Manhattan District Attorney's Office. So the president is not going to be happy about this day, but there is some wiggle room for him and his lawyers. I've been in contact with them, just waiting for their official response to what's happened today and what they're going to do next.
And you brought up something that we haven't yet talked about with Major or Keir, but you talked about pushing things till past the election. You can't really talk about this without acknowledging this umbrella over everything, which is the looming election and and I'm sure the president is painfully aware of the impact that these court decisions could have.
Oh, absolutely. The president has been trying to conceal his tax records, his financial records since 2015. And one of the big questions ahead of these two decisions was, well, okay, if the president loses on both sides, is there a possibility that voters could potentially get to see some of this information? Now, technically, information that goes to grand juries, information that goes to congressional investigations is not supposed to leak. But we know on the Hill, Anne-Marie, we all know, things leak. So the fact that that case was really decided in the president's favor, that makes it very unlikely that any of this information would actually get out before the election, and even that we will have any sort of resolution in the Manhattan case and a final answer on that before the election. But it is a loss for the president in Manhattan, while he has appeared to prevail for now in the congressional requests and preventing House Democrats from getting their hands on these documents.
All right. Paula, Keir, Major, Ilya, I love it when I get to just sort of sit in the center and just point at very talented people, and you guys sort of fill everything in. Really appreciate having you all in the clutch. Thank you.